This is Topmarké Attorney's information session on refugee appeals in Canada. I do see that we have a number of people in the room already. So I'd just like to thank you for making out the time to join us this morning. We do hope that this session will be interesting and as engaging as possible. So we'll just get right to it so that we can get things going. Right, so in terms of the ground rules, I'd just like us to go over that quickly so that we are all on the same page and have an understanding of what and how the session will be managed. So participants will be muted upon entry into the session. We ask that you kindly remain muted throughout the duration of this presentation to avoid distracting other attendees. We also encourage participants to send in their questions via the chat facility on the app during the course of the session, and we will do our best to address them at the end of this session. We may, however, make room for a couple of oral questions, and should this happen, participants would indicate interest by using the raise hand feature in the Zoom app. So if you look through your app, there's a feature there for you to raise your hand if you do have a question. So if we're going to use the oral option, we'll let you know, and so you can indicate by doing that. We also ask that participants kindly limit your questions to general questions only, and that you refrain from discussing your personal issues for confidentiality reasons. Specific questions or questions that may appear targeted or calculated to offend will not be entertained. And this presentation is provided for public information only, and reliance should not be placed on any representations made here as legal advice. We do not intend to create a solicitor-client relationship by virtue of any of our statements or conversations had during this presentation. That's very important and key. So just to reiterate that, again, this does not constitute legal or professional advice from Topmarké attorneys or any of its employees. It is provided for general purposes only. So you're accessing this information session doesn't create that solicitor-client relationship. You advise basically to seek out specific advice either by contacting us or your own legal representative where you have specific legal issues in relation to the subject matter of this presentation. The information provided here is valid as of today, and like human beings are dynamic, the law is also dynamic. Things could change after today. So this information is accurate for today and is not fit for particular purposes. So just important that everyone notes that. So just to deal with the overview of the things we'll be talking about today, we'll try as much as possible to introduce ourselves. We'll also be talking about who a refugee is generally. I do see that we have participants from within and outside Canada in the room, so it's important that we set the ground of what we're talking about so that we don't just jump into the appeal process while some of the folks who are participating today do not understand the background to get into a refugee appeal. So we'll discuss the refugee process at a glance, identify certain common issues that usually arise at refugee hearings or in refugee matters generally. We'll also try to discuss refugee appeals, the right to appeal, where a person does not have the right to appeal, what you need to do to commence an appeal, and the relevant timelines while dealing with your appeal. We'll also try to address the power and purpose of the Refugee Appeal Division so that people who have cases to deal with at the Refugee Appeal Division understand what that division really is about and what its objective in reviewing your appeal is. So we'll also deal with evidence and appeal. This is very important for anyone who has an appeal case at the Refugee Appeal Division. I will also talk about appeal hearings, when this is possible, and ultimately what the person can get out of the appeal process. There's certain developments that have happened recently with respect to refugee appeals in Canada. We'll also try to address that and conclude and open the room for people to ask questions. I'd just like to state, like the first slide you must have seen, this session basically is about refugee appeals in Canada. So it's not refugee appeals worldwide. Our scope basically is limited to what happens in Canada specifically. So in terms of introduction, who are we? We're Topmarké attorneys, and it's our pleasure to host you for this session. We're a fully integrated law firm with our specialty in the areas of immigration and refugee protection law. We do corporate commercial law as well, family law, litigation and dispute resolution, real estate law, mental health law, and employment law. Our partners have experience spanning over 60 years, experience gained in Nigeria, United Kingdom, here in Canada as well, and also in East Africa. Like they say, a couple of trees would not make a forest. So the firm is also enabled with a team of seasoned professionals that include associate lawyers, paralegals, immigration consultants, who are ready and available to provide you with robust legal services where you need them. So in addition to our practice areas, we represent clients in an array of immigration matters, refugee protection, like I talked about, immigration appeals, refugee appeals as well, judicial review, admissibility hearing, skilled immigration, spousal sponsorship, temporary residency as well, pre-removal risk assessment, humanitarian and compassionate applications. So this session basically relates to generally immigration. We do have a number of sessions lined up for you, and would just encourage you to look out on our social media platforms and try to get up to date as to what Topmarké has planned, particularly in the month of May and also in June. I do know that there will be a session tomorrow as well addressing student visas, study permits in Canada. There's also a session lined up for humanitarian and compassionate applications. Basically, there's a whole lot that Topmarké Attorneys is working on, and we enjoin you to come along with us and get the best of these informative sessions that we have put together for you. Just before I get right to it, it's also important that I introduce myself. My name is Tosin Falaiye. I'm an associate lawyer here at Topmarké Attorneys, and I will be coordinating or dealing with this information session today. So again, welcome on board. Right, so getting right to it. When a person hears about refugees, what sort of picture comes to mind? As a person, prior to dealing with refugee matters, I'd always thought when I heard about refugees that, you know what, I'm just seeing the sort of pictures you see on things like the United Nations, people living in tents, not living in proper human conditions as it were, people possibly fleeing from wars and all this kind of stuff. If you also have this kind of ideas in your mind, it's not far-fetched, but it's not totally correct. So there's a lot of myths and misconceptions about who a refugee is and the sort of conditions that refugees live with. It's not all people living in tents, people fleeing from wars. It's much wider than that. And so today, I just like to correct just those two misconceptions. There's a lot of misconceptions that people have about refugees and refugee protection generally, but a refugee, people feel that a refugee must be fleeing from war or disaster, and so people from places without these elements cannot be refugees. That's not correct. When we do get to the definition of who a refugee is, you will see that the scope of refugee protection is much wider than people dealing with war, disaster. Those are valid reasons to make a refugee claim, but that's not all there is to it. And refugees are human beings just like you and I. They do have rights. While they may not have the full scope of rights that a citizen in any particular country has, they do have rights that are protected and guaranteed by law. They do not live only in tents and camps and stuff like that. They live with decent conditions as well. So let's talk about it. Who is a refugee? United Nations states that a refugee is somebody who has been forced to flee his country or his country of nationality or residence. So you necessarily do not need to be fleeing from your country of nationality. You could have lived somewhere and have faced persecution and have reason to flee. So you're fleeing because of persecution, war, or violence. A refugee basically needs to have a well-founded fear of persecution for reasons of his race, religion, nationality, political opinion, or membership in a particular social group. So sometimes a particular social group could just be your gender. It could be what your sexual orientation is. It could be because you're part of a minority race in a particular region that is oppressed by the generality of the populace in that place, and you have a well-founded fear of persecution just because of that. So most likely in such a situation, a person who has such fear is unable to return home or is afraid to do so. War and ethnic violence, tribal and religious violence are some of the leading causes why refugees are fleeing their countries or need to flee their countries. In Canada, the law that deals with refugee protection is the Immigration and Refugee Protection Act. It provides two broad categories of refugees. We have the Conventional Refugee and persons in need of protection. So oftentimes where a person's claim does not fit into the definition of a conventional refugee, we could fall back into a person who needs protection by reason of some of these things I already talked about. So where you're dealing with your claim, your counsel will definitely guide you along those lines. So accordingly, where a claim can be situated within the broad scope of who a refugee is, it is more likely than not that a person will or may be granted refugee protection status, depending on where you're making your claim. So the refugee process at a glance. I'm just going to get a pointer here. Right, so I believe you can see the pointer I have right there at the beginning on the black tab or box there. When you want to make a refugee claim, you can either make it within Canada or at the point you're coming into Canada. At any point in time where you make your claim, somebody reviews it. They usually call the CBSC officers, and they determine whether or not your claim is eligible to be referred to what is known as the Refugee Protection Division. If your claim is deemed to be ineligible, you get to move out of the refugee stream into possibly the primary risk assessment stream. That's not the scope of this conversation here today. So that's not what we're talking about. But just bear in mind that if your claim is ineligible from the word go, you likely won't be put in the refugee stream. Eligible claims are referred to the Refugee Protection Division. Like I said, it is at this point you have the first opportunity to state what your claim is. You get an opportunity to prove your claim, provide documents to support your claim, evidence based on what you have, and have a hearing where your claim will basically be tried and tested for all the elements that a refugee claim needs to have. If you do succeed at your hearing before the Refugee Protection Division, I will be calling it the RPD going forward. You can then proceed to apply for permanent residence in Canada if you do desire to do that. For claims that are unsuccessful at the RPD, you get moved along to the Refugee Appeal Division, which basically is the main focus of our conversation here this morning. So unsuccessful claimants generally would have a right of appeal. It's not in every case that an unsuccessful claimant before the RPD will have a right of appeal, but on appeal, a couple of things could happen. You could succeed and get determined to be a conventional refugee or a person in need of protection, and that way you go along the green boxes that I have here. For a person who doesn't succeed at the Refugee Protection Division, the RPD, and does not have a right of appeal, you have the opportunity to go directly all the way to the federal court to do a judicial review, and we will talk about circumstances where that may apply to you. In other situations, there's a category of refugee claimants who are called legacy claimants, people who made claims prior to the establishment of the Refugee Appeal Division. In those cases, they also go to the federal court to seek a judicial review. So like I talked about earlier, if you succeed at the Refugee Appeal Division, I will call that RAD going forward. So if you succeed at RAD, you could be determined to be a conventional refugee, and you can go forward to apply for permanent residence. But you could also succeed at RAD, have your case, your appeal allowed, but the RAD member is unable to determine that you're a conventional refugee. In that sort of situation, you get sent back to the RPD to either start afresh or have a redetermination hearing. But if you do not succeed at appeal, you have one opportunity to go further to the federal court to seek a judicial review. Ultimately, the outcome of the federal court judicial review could lead you either, depending on how you go to the federal court, back to the RPD or back to RAD. So basically, that's in a nutshell what the refugee process is at a glance, from beginning to the end. If you do not succeed at the federal court, unfortunately, that brings the refugee process to an end for you. And you could then explore other options to ensure that you remain safe and away from the issues that you are fleeing from. So to common issues that usually arise in the refugee process. This is some of the things a person who has a hearing or has made a claim would have to establish in order to succeed. You need to establish your identity. Does the refugee board here in Canada believe you to be who you are or who you claim to be? Is there any reason, something in the evidence, something in the research that has been done that makes us to doubt whether or not you're truly who you claim to be? That could be a basis for a claim to fail. Ultimately, if your identity is established, the refugee board will look at your credibility. So basically, is the reason why you're afraid, is it true? The evidence you provided, is it consistent on all fronts? Your own testimony at the hearing, does it tally with the documents you've provided? Have you acted like a person who truly was afraid for their safety in the country of residence or nationality? Ultimately, looking at the definition we provided to refugee protection earlier, your claim must have a nexus, it must have a relationship. If you basically put together your claim and say, okay, this is why I'm afraid, but it has no bearing with race, religion, political opinion, as the case may be, then there isn't a nexus to the Conventional Refugee provision. There's also the question of state protection. Canada, yes, has signed up to treating people fairly across the world and protecting people who are vulnerable, but ultimately Canada would not step into the shoes of another state that is able to protect its citizens. The first responsibility to protect you is the government of your country or the place where you resided. So if that country is able to do the job of protecting you, Canada will not take up that responsibility. There's also the issue of delay. Are you taking steps to seek protection at the earliest opportunity? For example, if the issues you are afraid of started, say, January of 2018, and you waited all the way until May of 2020 to make a refugee claim, the question needs to be answered as to why you waited so long. Do you have a reasonable explanation why you didn't take steps to flee danger? It is expected that the person who truly is afraid of danger in a particular place will not remain in that place. There's also the question of reavailment. So did you move away from that place and go back there? Is there a reasonable reason why you went back there? Basically, going back to the place where you're afraid for your life is an indication that the subjective fear you need to have to succeed in a refugee claim is absent. So that could also be a problem for people making refugee claims. There also is the issue of internal flight alternative. This really is a big one, and I'll give an illustration. Canada has 13 provinces. If I live in Toronto, Canada, and I say there's a reason why I'm afraid for my life in Toronto, Canada will believe that there are several cities in Canada where I can go or move to and possibly be safe. So before I move out of Canada to seek for safety somewhere else, I must have made efforts or have a reasonable reason to believe that my life will not be safe, say for example, in Winnipeg, in Calgary, or even in Ottawa, as the case may be. So ultimately, where there is room for you to move to another part of your country to be safe, refugee protection law expects you to have explored that opportunity first before seeking safety outside of your country as well. There's also the issue of exclusion. So for example, I am a Ghanaian, but I'm a resident of Italy. I'm afraid for my life in Italy. Canada will not give me access to the refugee protection system because I have access to a safe country, being Italy, where I can go to and be safe from persecution. So Canada expects me to use that residency that I do have somewhere else to seek safety first before doing it in a completely strange place. So that basically is, in a general sense, some of the issues that people dealing with refugee process have to face. This list is not exhaustive, and other issues could arise. So sometimes these things are dealt with on a case-by-case basis. It will be important for you, if you're going through the system, to consult your legal representative to see what issues could possibly arise depending on the circumstances of your case. So now let's get to refugee appeals. So basically, this is the process of challenging a decision made by the RPD in respect of a claim for protection in Canada. The unsuccessful party before the RPD, this could either be the refugee claimant or the Minister of Citizenship and Immigration may decide to appeal the negative decision. So for example, if I make a refugee claim today and I succeed, to the Minister of Immigration, who is the other party in my case, that's a negative decision for him. And he could decide that, okay, you know what, I've reviewed this decision and I think there are problems of law, errors of law here, errors of fact, or mixed fact and law, and I want to challenge this. So succeeding in a refugee claim doesn't mean that that decision cannot be appealed. The Minister of Immigration, and we have seen that happen in a number of cases, even though it is rare, may decide to appeal the positive decision in a refugee protection claim. More often than not, most appeals are dealt with by the refugee claimants themselves, who have had negative decisions at the RPD challenging on the for reasons of errors of law, fact, or mixed fact and law. So generally, most claimants would have a right to appeal, but in certain situations, that right of appeal has been extinguished by operation of law. And so we're talking about the exceptions to the right of appeal. Where the RPD decision involves people known as designated foreign nationals, that right of appeal doesn't exist. You then have to go directly to seek a judicial review in such a situation. A designated foreign national basically is somebody who, for some reason of criminality, organized criminality, as where issues of terrorism, the Canada believes would constitute safety to the public, or Canada is unable to, in a timely manner, do a background check or investigate the circumstances that have led the person to come to Canada. So if you're designated as a foreign national, when the RPD makes a decision in your matter, you have to seek judicial review rather than an appeal. So for a person who makes a claim and the claim is deemed to be withdrawn, just as with any case, if you bring a case to court in the regular court system, you can withdraw it at any point in time. So also a refugee claimant has the privilege of withdrawing claims if they do want to do that. Certain claims could also be declared to be abandoned. Say, for example, you show by your actions that you're no longer interested in pursuing the claim to its conclusion. The RPD or the relevant division at the time may declare your claim to be abandoned. So, for example, you had a certain number of days to provide your basis of claim, and you do not provide it within that period of time, your claim could be declared abandoned as you haven't shown diligence in pursuing your claim. So in that sort of situation, your right to challenge that declaration of abandonment exists to the federal court. The RPD finds that a claim has no credible basis or is manifestly unfounded. In that situation, your right of challenge exists to the federal court. So no credible basis basically is having reviewed the evidence in your case, listened to your testimony, any witnesses recalled to support or establish your claim, the RPD finds that there is no substance in your claim. The evidence has no bearing with what it is you said. For example, your evidence says Y, and your testimony at the hearing is ABC, or it's completely disconnected. Is that sort of situation, a no credible basis finding could be made, and your right of challenge will exist in a judicial review, not on appeal. So the RPD decision involves a claimant that came to Canada directly or indirectly from a designated country. On the day the claim is made, that sort of decision will only have a judicial review challenge opportunity. As of today, the US is the only country that is so designated. And basically, there's an agreement that is called the Safe Third Country Agreement between Canada and the US, whereby Canada understands that the US respects the rights of people and gives opportunity for a fair hearing for people making claims. And so because of that agreement that Canada has with the US, people who had come directly or indirectly through the US to Canada, depending on the port of entry that you made or you came in through, may not have a right of appeal. This is the general rule. As with every general rule in law, there are certain exceptions, but again, that's not the focus of today's presentation. If you do have issues with respect to coming into Canada, making your claim, having come through the US, you would need to seek specifically legal advice to see whether or not you have a right of appeal in the event that a decision is made in your claim. So where the RPD decision involves a claimant who is a national of a designated country of origin, this is different from the one I just spoke about. The designated country of origin basically is are countries that Canada had listed previously as countries where refugees usually do not come from. For example, some of the countries that used to be on this list, Denmark, Czech Republic, Australia, and a number of other countries. But as of today, Canada, I believe sometime in 2019, had revoked that designated country of origin list. And so the present position in Canada is that there is no designated country of origin. And so this is unlikely to arise as of today. Other exceptions include the RPD decision involving an application by the Minister for cessation of refugee protection, or an application by the Minister for a vacation of a decision allowing a refugee protection. So let's deal with what cessation could be. So if there's a reason to believe that the reason why protection was granted to you has ceased to exist, the Minister of Immigration may bring an application asking for the RPD to cease the refugee protection that was granted to you. Vacation could also happen where it is discovered, possibly after you were granted protection, that you had withheld material information or had misrepresented in making your claim before the RPD. In that sort of situation, a vacation can be sought by the Minister of Immigration. And I'll give two examples, one for cessation. If you make a refugee claim that's granted and for some reason or the other, you reavail back to the country where you had fled from initially. For example, you flee from, say, the Dominican Republic, you get protected in Canada, but say a couple of years after, you go back to establish some business in Dominican Republic, establish yourself, possibly become a government official in that country. The Minister of Immigration in Canada could bring an application asking for protection that was granted to you to cease because the condition on which you were granted protection no longer exists. Reavailment is one indication that the reason why you were afraid initially is now dissipated. Again, in terms of vacation, where it is discovered that, for example, you made a claim in Canada without disclosing that you were a permanent resident in, say, Australia, and somewhere down the line, the Minister of Immigration finds out that, oh, this person who claims to be a national of Zimbabwe was also a permanent resident of Australia and should have been excluded from the refugee protection system initially, but failed to disclose that information. The minister could bring an application for the protection to be vacated because it was improperly obtained. So I talked about the refugee protection system and how you start the process. Just the same way with an appeal, a person will need to commence an appeal for an appeal to exist in the first place. And the process by which you can commence an appeal is by filing a notice of appeal. Basically, this is a form that extracts information such as who is appealing, how many people are appealing, what are your file numbers, the nationality of the people appealing, your date of birth, the contact information for the appellant, and if you're represented by counsel, your counsel could either be an immigration consultant or it could be a lawyer licensed to practice in Ontario or in other provinces in Canada. You would have to provide contact information for your counsel. We also like to know when the notice of decision from the RPD was issued and when the person appealing the RPD decision received the notice of decision. For certain appellants or refugee claimants, they usually would need to have a designated representative. And basically, a designated representative is appointed for parties who do not have the ability to understand the nature of the proceedings before the RPD. So if for some reason, maybe mental issues or your understanding of life, for example, a minor, you're unable to understand the nature of the proceedings, a designated representative will be appointed for you. When you go on appeal, that designated representative would either need to continue or a fresh person nominated to be appointed as a designated representative on appeal. Generally, minors or people with mental impairments are those who have designated representatives appointed for them. And so the notice of appeal must be filed within 15 days of receiving the decision from the RPD. So for example, if I receive a decision today, 15 days thereafter, I must have indicated that I'm willing to go on appeal or not. If I don't do that within 15 days, it will deem that I'm not interested in proceeding on appeal, and there could be adverse consequences for that. If you look on my slide here, I put a little screenshot of what the refugee, the notice of appeal looks like. So here's what the form looks like. You will need to complete this. There are 2 pages at least to this form. Just the front page that's here, that's listed here, basically. And where you're unable to meet up with the timeline required for you to indicate interest in going on appeal, you could seek extension, but this would have to do with some issue of natural justice or fairness. So in seeking that extension, you need to state why extension needs to be granted to you in this circumstance. There's also the point of providing 3 copies if you're submitting the notice of appeal at the IRB registry. You can also have the option of providing the notice of appeal by fax to the registry at the IRB. Now, so after you've commenced the appeal and indicated intention to challenge the RPD's decision, you then have time to perfect your appeal. Basically, when we talk about perfecting an appeal, this has to do with putting all the documents together in terms of evidence and your legal arguments, which supports the grant of your appeal. So whatever you're basing your appeal on, you put those things together. When put together, it's called the record of appeal. And you have 30 days after the reasons for decision is received. So let's get this clear. You had 15 days from after you received the decision to start the process. You also have 30 days from the day you receive the decision to provide your arguments and evidence why your appeal must succeed. So it's not 30 days after you initiate the process. That 30 days already is counting the day after you receive the reasons of decision from the RPD. So in providing your record of appeal, perfecting it, 2 copies must be provided to the Refugee Appeal Division, and the Refugee Appeal Division will then serve it on the Minister of Immigration. Remember at all times that in any case you're dealing with, there would at least be 2 parties to your case. So even though you've gone for a hearing and the Minister of Immigration did not actively participate, it does not mean that the minister is not a party in your case. So when a decision is made, the minister gets a copy. When you provide your arguments while you're challenging the RPD decision, the minister must also get a copy so that he or she can make a decision whether or not they want to actively participate on appeal. So the record of appeal ought to state whether or not a person is relying on new evidence. Basically, this is expected to be a statement contained within your record of appeal, where you indicate that, oh, I'm providing new evidence and my new evidence complies with the requirements for new evidence. We will discuss new evidence sometime later in this session. So along with indicating whether or not you are providing new evidence on appeal, you're also supposed to indicate whether or not you're requesting a new hearing and why your hearing request should succeed. Also included in the appeal record could be what is known as a transcript. For folks who have been to a refugee hearing, you recall that there was a microphone before you that the member must have advised you was recording everything that was said. Whenever a negative decision is made by the RPD, it usually will be accompanied with a CD that contains the record of hearing. So where you need to rely upon things that happen, exchanges that happen at the refugee hearing, it's usually best for you to transcribe the contents of that CD that you got so that you can make specific reference to a specific page of your transcript to say, this is what happened, but based on the member's decision, something was wrong here. So a transcript of proceeding can be included in your appeal record. But if you're not relying on it, there isn't a need to do that. But more often than not, the transcript is usually a valuable basis for you to challenge the RPD's decision. So you could either decide to include the entire transcript or just the relevant portion of the transcript. But ultimately, whoever transcribes the record of hearing must sign and declare that the transcript has been done accurately based on the record of hearing. In addition to that, you could also provide on appeal any evidence which the RPD refused to accept. Certain cases exist where we submit evidence before the RPD, and for some reason or the other, the RPD refuses to admit those documents in evidence. You have another opportunity on appeal to provide those documents to the RAD, particularly if those documents are relevant to the appeal you're bringing forward. For example, if the RPD made a credibility finding which a document that you sought to have admitted but was rejected, and RPD makes a credibility finding about that document, you could always on appeal put that document forward to say, this document is relevant to the appeal, but the RPD rejected it. I need you to admit it on appeal. Now, those documents that were rejected before the RPD, they're different from new evidence that can be submitted on appeal, but you can submit new evidence in your appeal record, but ultimately you must state how this meets the requirements for new evidence. We will discuss what the requirements of new evidence further down in this presentation. And finally, your record of appeal must include a memorandum. The memorandum basically is submissions, legal submissions on why legal submissions on why your appeal needs to succeed. So in the memorandum that you prepare, you're identifying what errors were made in your decision, whether there are issues of law, issues of fact, and how the transcript which you provided or other new evidence you provided are relevant to your appeal. And this document that is called a memorandum on appeal has a limit. So you can't just go off the rails to say all the things that you have. You have to find a way to concisely limit your arguments to 30 pages. If you're putting your arguments on a single sheet, but where your arguments is on a double-sided sheet, it's limited to 15 pages. Ultimately, the page limit is 15 pages, depending on how you put your arguments together. So like I said earlier, to every case, there are always two parties. And while you go on appeal, the Minister of Immigration is also a party. And the Minister of Immigration could choose to intervene in your appeal. Basically, intervention relates to where the minister decides to actively participate in your appeal matter. And for the minister has the opportunity to issue a notice of intervention at any time before a decision is made in your matter. So when you have 30 days to put your arguments together, the minister has the opportunity to, at any time before a decision is made, issue a notice saying that I want to intervene in this matter. So where the minister issues such a notice, it would have to provide who this appeal relates to, the file number, when he received the decision. He must also indicate whether or not he's requesting a hearing and why he wants a hearing on appeal. Just like you also had an opportunity to provide a transcript, the minister could also decide to provide a transcript of hearing, possibly where you did not provide the entire transcript, or the minister has a different version of the transcript from what you provided. The minister could also provide that, as well as indicate in his own memorandum any legal authority relied upon in support of his position why your appeal should not succeed. Just like you as well, the minister has 30 pages limit in putting the arguments together. The minister must also provide proof, what is called proof of service. Basically, this deals with evidence that I have provided my arguments to you, the appellant or the opposing party, while the minister is intervening on appeal. So whenever the minister decides to intervene in your matter, you also have an opportunity to reply what arguments the minister has put forward on why your appeal should not succeed. Where included in your reply to the minister's intervention record could be transcripts, relevant documentary evidence that you have not provided in the appeal record, or documentary evidence that responds to any evidence that the minister has provided. You should also limit the arguments you make in a reply record to issues that were raised by the minister. So you can't be raising fresh arguments in a reply record. It is expected that when you had the first opportunity to state your case, you have done so comprehensively. But where you are challenging issues the minister has raised, you must limit your arguments to issues the minister made and provide any legal authority that supports the position you are canvassing in your reply. If you have not requested for a hearing in your initial appeal record and the minister intervenes, you could decide based on what arguments the minister is raising to request for a hearing. And in that sort of situation, you need to also explain why you didn't request for it the first time, why you think a hearing is necessary at this point, and those issues will be determined by the RAD. In terms of limits of argument, 30 pages also applies here. You must also provide proof of service that you had served your arguments upon the minister. It's important to note here that where you're doing a reply to a minister's intervention, there is a time limit to do that. This must be done within 15 days after you receive the minister's argument. So it's important to note that, and I will say shortly why it's important to note that difference here. So a decision can be made in your appeal 15 days after the minister receives the appeal record. Remember I said earlier that where you provide your appeal record, you are required to provide 2 copies to the Refugee Appeal Division. The Refugee Appeal Division then provides 1 copy to the Minister of Immigration. And so the Refugee Appeal Division notes the day on which the minister received your appeal record. A decision can be made 15 days after that time, or 15 days after the due date that you initially had to provide your appeal record. So for example, if you fail to provide your appeal record within the time you ought to, 15 days after that time, a decision can be made. This is why it's important to keep an eye out for the timelines you have to comply with while on appeal, as if you delay unduly, a decision can be made to your detriment. And if a decision is made, the appeal comes to an end, and you then have to deal with changing that if there is merit in your challenge before the federal court. In addition to that, it's important to also note that only where a hearing, or unless a hearing is supposed to be held on appeal, it is open to RAD to decide your appeal within these 15 days that I already talked about. There is exception to that provided in law. Generally, RAD is expected to decide an appeal within 90 days, but where that 90 days, complying with 90 days is not feasible, the law provides room for RAD to do so as soon as practicable. So many people on appeal may be thinking, oh, I filed my appeal a little while ago, no decision has been made, it's been more than 90 days, 15 days has passed since I provided arguments, the minister hasn't intervened in my case, why has a decision not been made? Remember that although the law expects a decision to be made within 90 days, if that 90 days is not practicable, for example, because of the administrative exigencies that RAD has, possibly the availability of an appeal member to decide your case. At the moment, RAD has a lot of cases, so it's possible that administrative exigencies hasn't made it possible for the 90 days to be complied with. In such a situation, the law expects that a decision should be made as soon as it is practicable. So if a decision has not been made in your case, it's not completely out of place. RAD, I'm sure, will be doing their best to make a decision as soon as it is practicable. So all of this I've talked about so far is where you, as the refugee claimant, has decided to appeal. This is the process that applies to how the process will run. When I have to state my arguments, when the minister can decide to participate in my appeal, and the time I have to reply when a decision can be made. As I said at the beginning, there are always 2 parties to a case. So just like you have the right to appeal, the minister also has the right to appeal, even if you succeed before the RPD. So where the minister decides to appeal, the process is similar to what has happened. The minister must decide to do that within 15 days. The minister has 30 days to provide arguments why his appeal should succeed. The minister, when the minister provides his argument, you also have an opportunity to respond. The minister will also have an opportunity to reply any arguments you provide in your response. Basically, the process is the same in terms of page limits, when the decision will be made, and the timeline that applies. The major difference I would like to draw your attention to is that while the minister has the opportunity to intervene in your appeal, at any time before a decision must be made, or at any time before a decision is made, you as the refugee claimant, you have 15 days after receiving the minister's appeal record to provide your arguments against the minister's appeal argument. So let's get this clear. Where you are the appellant, the minister can decide to bring his arguments at any time, provided a decision has not been made. But where the minister is the one who comes forward to say, oh, the RPD granted this claim, I don't think it was done appropriately, there's an issue with the decision, I'm challenging it. Where you receive the arguments that the minister has put forward, you must indicate your intention to oppose it, and your arguments must be submitted 15 days after receiving the minister's appellant's record. Now, all along, I've spoken about the timelines you have to comply with an appeal. In certain situations, a party may not be able to meet up with this timeline. The rules and the law provides room for you to seek extension of time, but bear in mind that extension of time will not be granted as a matter of course. You must show justification why extension of time is merited. So where you're seeking the RAD to exercise discretion in your favor, you must show reasons, evidence why you couldn't meet up with the initial timeline, and why, in your case, it's in the interest of justice. It's not disadvantageous to the Minister of Immigration to grant your extension of time that you're requesting. So it's important to know that extension of time is not granted as a matter of course. Do your best as much as you can to comply with the timelines provided. But where you can't, there is room to seek extension. Now, this part of the presentation is very important, and appreciating or having an understanding of what the purpose of the appeal division is can help you in advocating your case on appeal or determining how to provide evidence on appeal. Basically, the RAD is a body set up as a safety net to catch any errors made by the RPD. Ultimately, the RAD has an error correcting role in determining appeals. So where you make your claim and you have a hearing, a negative decision has come about, if RAD has to review that decision, RAD must bear in mind that its responsibility is to find out any errors that may have been made by the RPD and do its best to correct it. So in making your arguments, it's important to sieve through the decision, sieve through the evidence that you provided to find out what errors may have been made in RPD's fact-finding role. Fact-finding basically is a determination of what the facts are in issue and making a decision upon that. So before RAD, errors can be corrected. And so it's important to bear this in mind while making your argument. The RAD is expected in trying to find out what errors may have been made before the RPD to conduct what is called as an independent assessment. So the RAD is not supposed to say, okay, you know what? Because I wasn't there at the hearing, I did not see the refugee claimant's conduct. The RPD member saw the refugee claimant, the RPD member possibly saw the original documents you provided as evidence to support your claim. The RPD member saw your demeanor, and because of that, I will defer. I will believe whatever the RPD member says because he was there. Except the RAD member sees that that presence at the hearing room puts the RPD member in some sort of advantage position. The RAD must still conduct its own independent assessment of the evidence, documentary evidence, as well as the record of hearing. So that CD I talked about, the RAD member has an obligation to listen to it afresh and make its own determination as to what impression it had listening to that hearing record. So like I said, it's only where the RPD was in some advantage position should the RAD choose to be guided by the RPD's view of the evidence. This is why it's important to usually have a transcript. This is why it's important to pay attention to what evidence you submitted. In several cases, many RPD members ignore, for example, the country condition evidence you provided, preferring their own what is called an objective evidence to your own country conditions evidence that you may have provided. Where it's possible that a blind eye was turned to your own evidence that contradicts the objective evidence available, you should canvass in your appeal arguments the contents of the country condition evidence you provided, for example, because from the decision, it may appear to you that the RAD member, the RPD member ignored that evidence. So it's important to bear in mind that an appeal gives you a fresh start of some sort. It's not a complete fresh start, but a fresh start of some sort that gives you an opportunity, a second opportunity at establishing your claim, depending on what errors the RPD member may have made in reviewing your evidence. Right, so like I just said that the appeal opportunity provides a fresh start of some sort to establish your claim, where the RAD is expected to determine what the issues are, what the facts are independently. Now, although generally there is no fresh hearing on appeal, the RAD member, like I said, is expected to listen to the hearing recording, review the documentary evidence, and make up his or her own mind about what the evidence suggests to him. While this offers a fresh start of some sort, it is not intended to correct a defective record or defective evidence before the RPD. So like I said, it gives you some fresh start of sorts, but you're not starting your claim afresh. You can't run away from any fatal errors you may have made before the RPD. So for example, if you, in testifying before the RPD, had issues with credibility, you may be able to argue on appeal that the RPD member's interpretation of your testimony was wrong. It should have been interpreted this way, and the RAD member will have an opportunity to see whether or not your arguments make sense, or whether or not he agrees with the RPD member. But ultimately, that evidence you already provided that is already entered into the record, you cannot run away from it. If you provide an evidence that may have been deemed to be fraudulent, for example, you provide an affidavit that supports your case from a witness that saw what happened to you in the country you were running away from. That affidavit was submitted without being signed. That problem that you had already at the RPD, you can't run away from it on appeal. You can explain it away, but it will be left to the RAD member to decide, okay, you know what, is it possible for a mistake to have been made in a commissioner of oath signing an affidavit on oath without the deponent having signed that affidavit as well? Those arguments can be made, but you cannot shy away from it, or you cannot try to correct defective issues that already arose at your initial hearing. So it is important that you make the best case at the first opportunity. So even though you know you have an opportunity to appeal, if things go wrong, you must do your best to put your best foot forward at the earliest opportunity. There is a limited scope in what evidence you can provide in appeal, and some errors that you make at the RPD hearing may be irredeemable if care is not taken at the onset. So having said that, I will deal with what evidence you can provide on appeal. Remember I said earlier, evidence that was rejected by the RPD can be presented again if it is relevant to your appeal. For example, the RPD may have rejected evidence that dealt with your credibility, but ultimately the decision was made on internal flight alternative. If you are presenting this rejected document again on appeal, but that document doesn't relate to the IFA findings that were made by the RPD member, ultimately the RAD member may come to a decision that says, you know what, yes, this document was rejected, but it is not relevant to the issue I am determining on appeal. So there is that issue there. So it's important to bear in mind that documents going in on appeal must ultimately be relevant. Now, in terms of new evidence, you can provide new evidence provided it meets the requirements of the law. One requirement, key requirement, it must be evidence that arose after the rejection of your claim. So for example, if you're providing evidence to testify or witness an incident that already happened before your claim was made, there will be difficulty in trying to push that evidence in. You ultimately would then need to show that that evidence was not reasonably available to you. So if it was evidence that you could have provided, for example, I see that my brother witnessed when somebody tried when a certain gang attacked me and tried to kill me because of something, and I still am in touch with my brother. My brother wasn't lost. I call him from time to time, but I didn't get an affidavit from him or a letter from him to witness, to state what he witnessed. I then want to provide this document on appeal. That document reasonably was available to me. I would need to explain on appeal why I didn't provide that evidence for that evidence to be admitted on appeal. So if it's evidence that you could not reasonably have been expected to have provided at the time of rejection, then that evidence may be admissible. For example, I provided evidence, document that you may not have reasonably been expected to provide on before the RPD. So I provide evidence from Mr. X who witnessed the danger to my life. But at the hearing, an issue arises as to the identity of Mr. X. For example, Mr. X states in his affidavit is Chukwuemeka Ezegbo, and the identity document I provided to support that says that he is Chukwuemeka Nnamdi Ezegbo, and for some reason or the other, the RPD member doesn't believe that it's one and the same person. You could then provide on appeal evidence that establishes that this witness who provided his identity document is still the same person that signed the affidavit, just missing out his middle name. That evidence, you could not have reasonably expected that this sort of issue would arise with the RPD member. And so because of that, you may be able to argue that this evidence is relevant, particularly if that document was rejected before the RPD or was deemed to possibly be fraudulent and stuff like that. It's important to note here again that the key issue is the time of rejection. So you could go for your hearing today and a decision is not made possibly until 1 month after. In that window, you have the opportunity to provide what is called post-hearing submission, so post-hearing evidence. If within that 1 month window, you could have provided this evidence you're bringing on appeal, but you did not, it may be difficult on appeal to provide that evidence on appeal. So you must note that your hearing ended today does not mean that your window to provide evidence has closed, especially if a bench decision was not made in your matter. What I mean by a bench decision is the member deciding your case right there in the hearing room. So if the member says, I'm reserving my decision, I'm going to come back to it, you always have the opportunity to go back home, see what issues arose at the hearing room, what problem came up with your evidence, and provide any evidence you think may address any concern that was apparent at the hearing. So if you do not take advantage of that window as well, it may be problematic to provide that evidence on appeal. And I'll give one example. A person may have prepared for their case thinking that IFA will be to, say, for example, the cities of Port Harcourt, Abuja, and Lagos for a Nigerian claimant or a person who was resident in Nigeria before. And at the hearing room, the member raises Benin City as an IFA location, but you hadn't provided any evidence about Benin City and why you may not be able to relocate to Benin City. A decision wasn't made in the hearing room. You still have an opportunity to put together documentary evidence that shows that IFA is not viable for you in Benin City after the hearing room, but before the claim was rejected. So the rejection timeline there is also very important. Right, so having talked about the general requirement for evidence to be one that arose after the rejection, one that was not reasonably available, or one that you were not reasonably expected to have provided before the RPD, there is another step of requirements your evidence must meet. First of all, it must be new. So that evidence arose after the hearing does not mean it is new. And I'll give one example. I may have an affidavit that was signed, today is 13th. I may have an affidavit that is signed May 16th, but a decision was made in my case on May 13th. With respect to the first requirement I talked about, that evidence will meet the requirement of having arose after the rejection of my claim because it was signed on May 16th. But the RAD member is also obligated to look into that affidavit that was signed on May 16 to see this affidavit signed on May 16th, what is it talking about? Is it talking about things that happened on April 30th? Or is it talking about things that happened on May 15th? If that affidavit deals with things that happened before the rejection of my claim, it will not meet the requirement of newness of the evidence. So although it arose after, it really isn't new. That person who signed it on May 16th could very well have signed it on May 12th for it to have been considered before a decision was made on May 13th. So that's the issue of newness. Is it relevant? I may get a legal opinion from somebody that discusses the credibility issues that arose in my hearing. For example, the validity of affidavit evidence in Nigeria. But my IFA, the determinative issue in my appeal then is no longer credibility. It now goes to IFA. As long as that new evidence I've submitted is not relevant to the IFA decision or IFA determination, it will not be admitted before RAD. So it must be new, it must be relevant to the issue on appeal, and then it must be credible. Just the same way at the RPD, credibility issues could arise with the evidence you provided. For example, was the affidavit signed? Was the letter dated? This email you received, how do we know it was received from the person you claim for the person you claim that sent it? Those credibility issues can also arise on appeal. So where you are providing evidence, it's important to address that evidence is credible. How did you find it? How did you get this evidence? How was it sent to you? On what day did you get it? This person that sent it, what's the proof that the person is even real? Those sort of things, you need to speak to them in advance so that you satisfy the RAD member that your evidence is credible. Importantly also, it must be material. Materiality and relevance sort of are interwoven. So it must be material to the determinative issue on appeal for it to be accepted. It's also important to note that, like I said, this new evidence usually is submitted with your appeal record. So it goes together. All these arguments, you must have made them at the time you were perfecting your appeal. But refugee processes are forward-looking. So it's not static. The fact that I fled persecution in 2017, but my case is determined in 2019, doesn't exclude or limit the member to considering things that only happened in 2017. This is why it's important for you as a refugee claimant, a refugee applicant, to constantly keep possibly tabs. This is important to me because many people make refugee claims and do their best, understandably so, to move beyond the problems that they had. But it's important to know and keep an eye out for example, what are the country conditions in the country I'm fleeing from? Have the conditions changed from the time I made my claim or from the time I perfected my appeal? Is there anything that's happening in that country that further puts my life in danger that I need to provide evidence of that may even help change the decision that I'm appealing? It's important to keep tabs on what is happening that is relevant to your case. For example, my persecutors, the people that are out to harm me, what are they doing about me? Have they just gone to bed? Again, forward-looking. If I made my claim in 2017, and as of 2020, the condition I'm afraid of no longer exists, then on what basis is my claim supposed to be granted? This is why it's important to not just go to sleep thinking that, okay, yeah, Canada has let me come in, Canada has let me make a refugee claim, and so it's now uhuru for me. No, until your claim is granted, it's important to, as much as you can. I'm not saying put yourself in situations of danger, but at least try to keep a window open to see what is going on, what's happening in my country, how is it relevant to me, what's happening with the situation, the specific situation that affects my life, and do I need to provide evidence of this thing? Is it relevant to me? Not just limited to whatever was happening in your country, but also in this country that you are now in Canada. Are there situations that you are faced here in Canada that may endanger your life? For example, I may have fled Nigeria because of domestic violence, but in Canada, I may have come across possibly a gang that is out to deal with me, and that gang has ties to the country where I was living before. it is relevant to my refugee claim to put forward evidence that says, you know what, this person I had a problem with here in Canada has said to me that if for any reason I can't deal with you here in Canada, whenever you get to Nigeria, I'm going to deal with you. That evidence is relevant. It will be new if it arose after the perfection of your appeal. So up until a decision is made in your claim, the room and opportunity is there for you to provide evidence that is relevant to your claim as a refugee claimant in Canada. So after you have perfected your appeal, you can bring forward evidence, but you must seek the permission of the Refugee Appeal Division. And you must explain how it meets all of these requirements I've talked about before, how it is new, how it is relevant, how it is credible, and how it is material. So keeping tabs in your situation is very important. Do not go to sleep until you get the goal or the protection that you're looking out for. As a general rule, appeal hearings, as a general rule, the law provides that appeals are to be determined without a hearing, basically on the evidence you provided at RPD and the evidence you provide on appeal. So a hearing is not supposed to happen. It's supposed to just be on your argument. But there may be a situation where a hearing is necessary. And first of all, for a hearing to be granted, new evidence must have been admitted. So a hearing may happen where new evidence that is admitted raises a serious issue with respect to the credibility of the person who is the subject of appeal. So I submit this new evidence. There are credibility concerns about this document that is relevant to me as the appellant. It is central to the decision for protection in my case. And if this document is accepted as credible, it may lead the member to either accept my claim or reject my claim. It's important in that sort of situation, the member has credibility concerns about that evidence, the member may then order a hearing. One ready example is this. I made my claim about matter X, say I was persecuted because of my religion in Zimbabwe. But I've come to Canada now and I've become a political activist. And I'm speaking about the political issues in Zimbabwe. The Zimbabwean government has taken notice of this and has issued threats to me if I ever return to Canada, to Zimbabwe. If I provide those evidence or evidence of that new situation that arose after I came to Canada, and the RAD member has concerns about the credibility of the evidence I provided, there's a possibility, even though it is rare, there is a possibility that the member may decide to order for a hearing to be held in that sort of situation. Because if he finds that document to either be credible, it may lead him to say, you know what, you're a person in need of protection, or you're a conventional refugee. Or it may lead him to say, you know what, I've reviewed this document, I've asked you questions, you've not satisfied me that this document is credible, I ultimately reject your claim. A hearing may be necessary in that sort of situation. Where a hearing is ordered on appeal, it often is limited in scope to the issues that the new evidence raises. So again, like I said, refugee hearings is not a complete fresh start for you, but it's a fresh start of some sort. So you're not going to be going back to the issues that were already dealt with in your RPD hearing, but you'll be dealing with questions and testing the new evidence that you have raised, as well as the issues those new evidence raise, as it were. So that's the circumstance in which an appeal hearing can be ordered. And so where an appeal hearing is ordered, you will be given notice of that hearing, just the same way you prepared for your RPD hearing. It's important to prepare for that. Go over your evidence again. Go over the new evidence you provided. Go over what circumstances are happening in your country as of the present time, and see, do I need to add to the evidence I already provided, or what I provided so far, is it sufficient? Get your witnesses together. Any witnesses you may have, get them, have them prepare, ask yourself questions. You know what? This thing I said, who did it happen to? When did it happen? Why did it happen? How did I get to know? Those sort of questions you already experienced at the RPD hearing, prepare for it again, because the hearing pretty much is similar, only that it is limited in scope to the new evidence you provided on appeal. So having talked about all of these processes up until the the appeal hearing, if one arises, we will then discuss the potential outcomes on appeal. The negative decision that could happen when you go on appeal is the confirmation of the RPD's decision. If that happens, it means the RAD member agrees that ultimately the decision reached by the RPD member was fair, was reasonable, and he has no reason to set it aside. That sort of situation is negative, and we discussed that earlier. Where a negative decision comes out on appeal, you have another opportunity to go to the federal court. The best outcome you could have on appeal is that the RAD member sets aside the decision of the RPD and substitutes it for a decision which the RAD believes ought to have been made in the first place, or ought to be made given the new evidence you provided on appeal. So remember, we said earlier, it gives you a fresh start of some sort to reestablish your claim. The RAD has an obligation to correct errors and has similar powers as the RPD has to find you to be a conventional refugee. So it's important to do your best as much as you can to advocate for this best possible outcome. And if you do get that, you can go along the path in my green tab at the beginning of the presentation to apply for permanent residence. There could also be a situation where the RAD member agrees with you that some error was made that is fundamental in your case, but ultimately, based on the recording of the hearing, the review of the evidence, the member doesn't feel is in a position or has sufficient evidence to come to this best possible outcome, right? Or come to the negative decision I discussed above. In that sort of situation, the member could either send you back to RPD for a redetermination or a de novo hearing. A de novo hearing basically is you starting the refugee process more or less afresh. So everything that happened before may be wiped away and you start your case afresh. A redetermination hearing, different from a de novo hearing, is one where you go back to have a fresh hearing, but doesn't completely wipe out whatever was decided upon or whatever questions were asked before. What may happen in a redetermination hearing is that the decision is set aside, the hearing CD is still there, the new hearing member can make reference to whatever happened in that transcript, in that hearing, initial hearing, but ask you questions in a fresh hearing to redetermine your claim and take a fresh look at the claim, but not completely wiping out the slate. So basically, those are the potential outcomes that could happen. A negative decision, you go to judicial review. A positive decision that leads you on your path to becoming a conventional refugee and protected person, going forward to permanent residence. And the last outcome, a positive decision will send you back to the RPD to have another hearing. Now, recent developments. A lot of Nigerian claimants must be aware of what is called the jurisprudential guide, especially if your case are dealt with what we call non-state agents. And so the jurisprudential guide basically addressed IFA for Nigerian claimants fearing non-state agents. Non-state agents are people who do not represent the government. So, for example, I'm afraid of Chief Agbabiaka. Chief Agbabiaka is not a government official. The reason why I'm afraid of Chief Agbabiaka is not related to his position, any position in government. Chief Agbabiaka is not persecuting me on behalf of the government of Nigeria. He's persecuting me possibly because of private issues, personal issues between myself and Chief Agbabiaka, maybe a business relationship gone south. In that sort of situation, Chief Agbabiaka, who has made Nigeria unlivable for me, or the part of Nigeria where I was unlivable for me, is a non-state agent. And generally, it is believed that non-state agents in Nigeria may not have the capacity to make the entirety of the 36 states in Nigeria unlivable for a person. So general rule is that where a non-state agent is involved, IFA is generally available to such a claimant. But the IRB now has come up with a decision to say that the country conditions that were discussed in this jurisprudential guide with respect to making IFA generally viable for claims involving non-state agents, those country conditions are more or less changed in such a manner that reduces the value of the jurisprudential guide as a guide to apply in all cases rather. So just to be clear here, the revocation of the jurisprudential guide is not that the jurisprudential guide is completely useless. It does not mean that IFA is no longer applicable to Nigerian claims. It means that IFA is still there, but the manner in which the jurisprudential guide used to be adopted before will no longer be done, but that decision still has a persuasive weight. Persuasive weight is something that a person is not bound to follow, but can reference in terms of being guided by what that decision said. For example, that decision has said there's a two-pronged test for IFA analysis to be done. Is there a serious possibility for me to be persecuted in the location? Is it reasonable in all circumstances for me to relocate to this IFA location and live there? The decision also provided certain factors that need to be considered. For example, transportation, employment opportunities, education. Those principles may still be persuasive to an RPD member or a RAD member, but the country conditions that the jurisprudential guide talks about is what has been revoked. So it's important to look at your decision and see what happened there and see what conditions in your country are as of today and how we relate to your case. So like I said, the underlying principles with the jurisprudential guide contains can still be of persuasive value to decision makers, examine the influence and motivation and reach of a persecutor in arming me in a new location, or examine factors such as transportation and travel that may determine whether or not it is reasonable for me to move from, say, Lagos to Benin City, or from, say, Lagos to Port Harcourt, or, say, Lagos to Ibadan, as the case may be. Each applicant must thus review the decision in their matter, possibly with your counsel, where you were represented. If you were not represented, also take a look at it, try to see how did the jurisprudential guide apply in my case? What country conditions did the member rely upon from the jurisprudential guide? And are those conditions still the same thing in Nigeria as of today? If you find differences in it that are material in your case, it will be a good thing to put forward those arguments. If you are represented, it will be a good thing to talk to your counsel to see, you know what, hey, this is what this member said about the jurisprudential guide in my case. This is how it was applied. This is what's happening in Nigeria today. I don't think these things don't add up. What do you think? And you both together come to a decision to provide that new evidence that I talked about. If your case is still pending, the appeal hasn't been perfected, there's that opportunity. If the case is still pending, appeal has been perfected, but a decision has not yet been made, there's that opportunity for you to put forward that evidence before the decision is made. Now, recent developments, that's a jurisprudential guide. So ultimately, review your decisions and talk to your counsel to see what needs to be done in your situation. COVID-19 has sort of affected everything around the world. As of today, the IRB's front offices are not open, you're not attending to people in person. And so right now, for notices of appeal and appeal records that fall on or after January 1, 2020, a temporary extension has been granted until 30 days after the resumption notice is issued. So basically what this means is, if you had 15 days initially to file your notice of appeal on January 1st or after January 1st, and you haven't filed it, there is a 30 days extension that has been granted to you. That 30 days will kick in when things return to normal at the IRB. They will reissue what they have called a resumption notice. So from the date that resumption notice is issued, you then have 30 days. The same thing will apply to you if you had an appeal record to put together. You then have 30 days to submit and perfect your appeal record. It's important to note that this extension does not apply to appeals that were dismissed before March 15, 2020. So if your appeal was dismissed before March 15, 2020, when indeed the COVID-19 issue sort of started shutting down things, this extension does not apply to you. Now, let's unpack the implication of this 30 days extension. For a person who had a deadline initially of March 10, and a person who had a deadline of March 16, one who had a deadline of April 30th, the resumption notice will be issued on the same day. Everybody, all those different deadline dates, will then have 30 days to submit their appeal or perfect their appeal on the same day, 30 days after that. So when operations begin back normally, everybody's record will be due on the same day. So when you look at this critically, it may not do you any favor to leave the perfection of your appeal or indication of your interest in wanting to bring an appeal until when things return to normal. And I'll give an example that you may be able to relate with. For example, for a person who is represented by counsel, counsel has maybe 5 appellants who, when the resumption notice is issued, all the appeals are due on the same day. Counsel then has to work a short timeline and stuff like that. I don't think anybody wants to be in a situation where, given the opportunities that everyone has now, sufficient time can be put into thinking through the issues, the errors of law, errors of fact in your case, to put a solid job in, and then you want it to go into a situation where everybody's rushing to perfect their appeal at the same time. So as best as you can, if you're putting your arguments together while things are relaxed, start putting those arguments together, start thinking it through, ruminating on what arguments you put forward, talking to your counsel where you're represented to ensure that a solid job is done as much as possible. And again, if you perfect the appeal before the resumption notice is done, remember there's always still that room to provide additional evidence that may be relevant in your case. So as much as possible, take advantage of the abnormal situation that we have right now, and do your best to put the best argument forward, not leaving it until the last minute where things may be rushed just to get your arguments in. So that basically is it about recent developments. There's also the issue of bearing in mind that evolving situation around the world, country conditions are changing. Ghana is not the same way it was, say, on March 1st. Nigeria is not the same way it was on March 14th. Canada is not the same way it was on January 1st. So country conditions are changing. It's important for you to bear in mind that refugee claims are forward-looking. Refugee appeals are forward-looking. Succeeding in your claim, there is that possibility that it may be considered on a forward-looking basis. So what are the country conditions in the country you are fleeing from as of today? How is it relevant in your case? Do you need to discuss with your counsel about that? Do you need to discuss with yourself to say, you know what, this is the decision that was made in my RPD claim, or even if my RPD claim is pending, this is the situation I'm on the run from. This is the country condition in my country. This is how it affects me if I ever have to return there. Is it relevant to your claim? Do you need to put forward that evidence right now? You need to be thinking about those things, seeking legal advice where it's necessary, talking to people who know about it, and doing your best not just to allow things pass you by. So that basically is it running from the overview. I will just conclude by just reading my conclusion that I have here. Refugee appeals present people with in need of protection with a unique opportunity to correct any errors made in the determination of their claims and show evidence of any developments that affect and further establish subjective fear a claimant has in returning to the country of persecution. However, many claimants understandably flee persecution and look to completely close the door on the past, even before the claim is conclusively determined. This is done forgetting the fact that refugee claims are forward-looking and some claims may not be determined soon after the claim is made. What happens then in respect of a claimant who is required to show a continuing motivation of the persecutors to inflict harm, or that the condition in the country of persecution is the same as when the claimant fled several months or years before, but has lost touch with the past. It is thus important that while maintaining a physical and possibly social distance in this time from the past, a little window is open to keep tabs on the activities of your persecutors and the persecutory situation in relation to how it affects you as a claimant, so that at any time you are able to utilize the privilege of providing developments and updates in your matter that may shift the needle in the direction that you desire. Ultimately, in summary, refugee appeals provide a valuable second shot at proving your claim. Okay, thank you all for still staying with us so far. So we'll be heading right into the questions now. I have a number of questions that were already received here. Move this over here. So someone is asking to know whether or not, or what happens in terms of a conflict between a person's version of a claim and a different version coming from the government of that particular country. Like we have said earlier, people should try as much as possible to refrain from asking specific questions. So I'm just going to read the question out as generally as possible. Ultimately, what happens if there's multiple versions of your claim, as it were? The obligation is yours to bring the best evidence that you possibly can about the issue you are faced. Oftentimes, no country will publicly say or admit it's persecuting anyone. So it is up to you who experienced the issue you are afraid of to put forward the best evidence that you have so that we do not distract others. Thank you. So that's about that. It's up to you to provide the best evidence you have available. Things that you experience possibly may have been reported in journals, independent news sources. You may have been issued certain documents if you were arrested, for example, or incarcerated for a number of days, or as the case may be, your property may have been damaged, pictures and things like that. There is always evidence that would corroborate what situation you faced. So regardless of what anybody says to the contrary, do your best to provide subjective documents for yourself and documents that may be objective in your circumstance. And then also bear in mind that Canada also has channels by which it does independent research about what is going on in various countries. So whether or not the government of the country says something else, there may be objective evidence out there that you can use to support your situation. So somebody here says that for an appeal that may have been submitted over a year ago and no information has been received from RAD so far. Like I said at some point in this presentation, the law expects that a decision should be made within 90 days, but the law also leaves room for situations where 90 days may not be feasible. I also made reference to the fact that there's a ton of cases before the Immigration and Refugee Board generally, and also before RAD. I do know that at some point, new members were appointed. So we're seeing that different from early last year, cases are moving faster along. So chances are that when things come back to normal, a decision may be made in your claim, or you may receive your decision if one has not been made. I mean, if one has been made but not posted to you yet. So I will say to keep your fingers crossed, keep tabs on what's happening in your situation, see how you may, if possible, update what's going on with respect to you, and just keep hope alive and keep doing your best to advance what you're doing here in Canada and also with respect to your claim. One thing Mr. Babara usually says, and I think will be valuable in this situation, is as a refugee claimant, don't make a refugee claim and go to sleep, whether it's in terms of keeping tabs on your case or even doing stuff in Canada. Ultimately, the time you spend waiting for your claim should not go to waste, whether it's in getting a new skill, do the best that you can to ensure that this period, ultimately, whatever happens, does not go to waste. So there's something similar here as well with respect to knowing the status of your claim. You could always write a letter to the RAD to see what's going on in your claim. But in my experience and our experience at Topmarké attorneys, there usually is a generic response that just says that claims will be determined based on the administrative convenience of the refugee appeal division, or as the case may be, even before RPD. So ultimately, it's a subject to the availability of members, whatever checks need to be done in respect of your file. These files go through a certain process before decisions are made. So those things will need to be done before a decision happens in your case. So my guess would be that if you do that, you probably will get the same response, but there's no harm in trying. So you can always write to them to see what's going on. Right, so a claim that was rejected based on the Jurisprudential Guide on IFA, can you update your claim, which update your appeal with RAD since the JG has been revoked and cancelled and a decision has not been made. Yes, I emphasized on this a lot during the presentation. Look at the jurisprudential guide. Look at your own decision. Say, for example, the jurisprudential guide talks about all sorts of factors. The RPD member may have only picked, say, one factor. For example, language. Member may say, okay, you know what? You speak Yoruba, and in this location, they also speak Yoruba because the jurisprudential guide says they speak Yoruba there as well. What does the current country condition evidence show about that location? If the member had concluded in the RPD that Yoruba is spoken in a place like Benin City, for example, do the current condition documents of Nigeria support that position that was taken in the jurisprudential guide? Has it changed today? Do you have evidence to show that Yoruba is not spoken in Benin City? If you have this sort of evidence, why not? The JG talks about things like transportation and travel. Says it's possible for you to travel to, say, Abuja. Abuja has international airports. Is it possible for you to travel to Abuja today? Is the international airport operating? That's a country condition that may have changed because of COVID-19. It is important to look out for those things, how they happen in your case, and what evidence happens is in place today, and updates your appeal, or even your RPD claim if your claim is pending before that division. Now, can a minister of immigration still bring an application for cessation of vacation after the refugee claimant becomes a Canadian citizen? My answer to that will be yes. It is possible if facts arise that, you know what, you misrepresented to get what led you to citizenship in the first place. So it is always open to the minister to decide when and why to bring that application, which is why it's important, and we always try to emphasize that refugee claimants must be truthful, must do their best to get correct evidence, genuine evidence that will stand the test of time. You never know what could happen. It could possibly be while a citizenship application is made and deeper background checks are being done. So we do not encourage anyone to make claims on fraudulent or misrepresenting evidence and things like that. So it's open to the minister to decide when and why to do what. Well, so somebody here is asking about a claim that has been denied and waiting for a prior assessment. A prior assessment basically is a pre-removal risk assessment, but in many cases, this can't happen until a year after your refugee claim had come to an end. This person is seeking to know, how do you address a situation if the person has been removed? I mean, you can only apply prior in the process of being removed. So if you're not qualified for prior while a removal process was commenced, it may be difficult to decide what to do, but here's what I would say at this moment. We do have a session on deportation and removals. I will enjoin that person to join that session. Hopefully before we're done, I will confirm when that session is supposed to hold. But I do believe that session may have been recorded, and so we will consider internally posting this on our social media. Right, so the person says that an appeal was submitted last year, and to date, nothing has happened. Having made calls and contacted RAD, information was provided that it has been assigned to a decision maker, and what should the person do? Like I said during the presentation, provided evidence has, provided the decision hasn't reached you, you can still put in that evidence. So whether or not it's been assigned to a member, whether it is pending assignment, whatever the case is, so long you do not have possession of a decision, put in that application of evidence that is relevant to your case. So this person wants to know, and this is the question that wasn't clear, so says a claim can be for protection or conventional refugee claim. Right, so where a person makes a claim in Canada, it could either be considered under Section 96 or Section 97. Section 96 deals with the convention refugee, like I said, two broad categories of protected people in Canada, conventional refugees, and persons in need of protection, your claim could either be granted on one of those two sections, right? And so if you initially registered a claim for conventional refugee, can you withdraw and file a fresh claim for protection? Well, what I would say with respect to that is, if you were making your claim only on Section 96, and I think that that's an unusual situation, for a person who is represented by a legal representative, as much as possible, it's good to cover the field to ensure that either on Section 96, on Section 97, your claim can be considered. So chances are that if you're represented by counsel, counsel is pursuing your claim under Section 96 or Section 97. But if it's a situation where your claim for protection as a person in need of protection is based on an entirely new facts, I wouldn't exactly advise withdrawing the initial claim. I expect that that claim was genuine and legitimate initially. What you can do is provide an update to your situation that will then situate your claim within Section 97. So you already have that claim here, therefore, under Section 96 as a conventional refugee, you have an issue that deals with a person in need of protection. Provide an update to your situation and leave it open to see which you are able to prove and which will get you the goals that you want. But what you can do in such a situation is provide an update that is genuine, that is true, and that you are able to prove and establish. Right, this person is asking about claims being covered by legal aid and wants to know what it will be to retain our services. For retaining our services, I will say to contact us. The information is there. Reach out to us, info@tpmattorneys.com. But for lawyer who is legal aid empaneled and is empaneled for appeal matters, you may be able to utilize legal aid for that purpose. So it ultimately will depend on your lawyer's relationship with legal aid and whether or not the lawyer is empaneled for appeal matters with legal aid. But for retaining our services, we have about 5 minutes more, and those are the questions I have listed here. I will just make an attempt, okay, to see if there's anyone that I can give an opportunity to ask an oral question. So I'm going to come to somebody by the name Yetunde. If you're there, that one question will take orally and then bring the session to an end. So if Yetunde is there, you can ask your question now. Let's try as much as possible to make it brief and remember the rules. Okay, so Yetunde has muted herself back. I assume that that question will not be asked. Okay, so ladies and gentlemen, again, I want to thank you for joining us for today's session. It's indeed been a pleasure hosting having you with us today at Topmarké Attorneys. Our social media handles are posted right there. Facebook, we're at TPM Attorneys LLP. On Twitter, we're at TPM Attorneys. On Instagram, we're at tpm.attorneys. And we also have a YouTube channel, Topmarké Attorneys channel. Please do yourself a favor by joining us on all these platforms. Reach out to us at info@TPM Attorneys. Also check out our website for information of things that we're doing time to time. Like I said earlier, we have a session tomorrow on study visas, also a session on humanitarian and compassionate application. It may also be worth considering preparing yourself if eventually you may need to file humanitarian and compassionate application. For the folks who asked questions about pre-arrival risk assessment, which basically deals with an assessment of the risk you will face if you are being deported from Canada, there is also a session on that. I did say earlier I will find information about when the session is happening. So the HNC session is on May 15th. Investment session is on May 21. Pre-arrival risk assessment is on May 19th. So May 14th tomorrow, study visas. May 15th, HNC applications. May 19th, deferral request, stay motions and preliminary risk assessment. May 21st for the business immigration session. A lot of things are happening during this period. Do yourself a favor and try to get as informed as possible. Like I say, information is power. The information you get freely, you never know what it will do for you. Thank you once again. I wish you all a very wonderful rest of today. Keep doing your best to stay safe, and hopefully we get to see ourselves when things return to the new normal.